crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis, Wright.
Good evening and welcome into the attorneys. Thank you so much for joining us tonight. Got an interesting panel assembled, a topic that I think will apply to many of you that are watching. You're going to want to stick around for that. Before we get to our introductions, just want to remind you of how you can join the conversation. There are ways you can call, text, email. That information displayed at the bottom of the screen all throughout the program tonight. So plenty of opportunities for you to join our conversation. To make it easy, if you'd like to text us, that number 205-670-1949, or you can call us toll free 844-LAW-TALK. That number is 844-529-8255. Also, Hollis Wright makes available each and every Sunday evening for the duration of the show attorneys who are standing by to speak with you. So you can call, text, email them, and you'll get a response as well while the show is on the air tonight. So take advantage of that. Leading our conversation for this evening's show is Carter Clay from Hollis Wright. Good to see you,
Good evening,
sir.
David. I hope you're doing well.
Doing well. How about you?
I'm doing great. Yeah, tonight we're going to be talking about mortgage foreclosures on homes. Wouldn't it be so nice if everybody had enough cash to where they didn't actually have to borrow money to buy that house? But unfortunately, as we all know, that is not the case. Right. And what is the case, though, is that home ownership or the purchase of a house is typically the largest, most important purchase or investment a person will make. So this is a topic that is very relevant to all the viewers out there this evening, to make sure that they don't get themselves in trouble, make sure that they don't get behind on their mortgage payments, and to allow them to understand what their rights and responsibilities are if that unfortunate event occurs. Statistics right now in Alabama indicate that there are about 11,000 homes that are actively involved in the foreclosure process right now. And of course, the numbers are much bigger on a national basis, but that'll give the viewers some idea as to how big of a problem this is in our society. And of course, as we experienced in 2008 and 2009 and beyond, when we had the economic crisis, it really got bad. But we are very fortunate tonight to have Matt Carroll here with us. He's an outstanding attorney in the Birmingham area, and he's going to help guide and navigate us through this topic of mortgage foreclosures and talk with the viewers about what they can expect if they get themselves into a situation where they can't pay their mortgage. So welcome to the show.
Thank you, David. Thank you, Clay, for having me.
Sure.
I really appreciate being here. And yes, as you mentioned, you're exactly right. Home ownership, most financial advisors that will tell you that home ownership is the key for most families in building wealth. It is also beyond just the financial benefits of home ownership. A lot of, even the courts have recognized that the home has a psychological and emotional connection to most people that makes the loss of a home more than just the loss of the financial investment. It's also something that will create a great sense of stress, an emotional disturbance for people, and it's just something that most people could avoid if they handled it the right way.
Yeah. Tell us a little bit about your background and where you practice and how you got involved in this area of the law.
Absolutely. I've been practicing for about 20 years. I practice at a law firm called Johnstone Carroll. It's me and my partner, Inge Johnstone. I really fell into this, to be honest with you. I fell into this for a long time. I worked for a defense firm, and I was representing mortgage servicers for a defense firm. And found that work to not be that satisfying. I saw a need for lawyers who understood this process, understood some of the federal statutes that govern this area, and in 2014 left my old firm, joined up with my current partner, and have been practicing in this area ever since.
Now, in terms of your practice in this area of the law, you would be retained or representing individual homeowners and not the mortgage companies. Is that accurate?
That's right.
Correct. Well, one of the things I think we need to kind of talk about on the front end a little bit is Obviously, if somebody's behind in their mortgage, they probably don't have a lot of extra cash laying around to be able to pay an attorney. Can you talk a little bit about how you are retained, what the scope of your services are, how you get paid, and whether or not there is law out there that would allow a consumer or homeowner to potentially have their attorney's fees paid for them?
Absolutely. So what I would say is this, when you're talking about this area, and you're talking about the specific situation you mentioned where there is a homeowner who may be having some financial troubles in the short term, there's not a lot of state protections for them. There is, however, a very strong federal statute that will assist them, and that statute is called the Real Estate Settlement Procedures Act. In particular, there is a provision of the Real Estate Settlement Procedures Act that was enacted in 2014 after the 2008-2009 mortgage crisis you mentioned, that gave a structure, was designed to address some of the abuses and some of the problems that happened in 2008 and 2009 by creating a framework by which homeowners, if they are in financial trouble, could apply to their mortgage servicers for some type of relief. And that relief can take different forms. It can take the form of a short-term forbearance in their payments. It can take the form of a loan modification that may result in lower payments. If there is as unfortunate as it is, there are simply some circumstances where the homeowner is in a house they just can't afford. And I hate that that's the case sometimes, but sometimes it is. Yeah. In that case, what RESPA will allow, or if you invoke your rights under RESPA, what the homeowner can do is work with the servicer to sell the house in a way that will cause the least amount of financial harm to them in the long term. Hopefully recoup some of their investment, maybe take some of the sale proceeds and buy a smaller house. But to answer your question, the rest of your question, how we help, the loss mitigation options I've discussed with you, those options, if they're invoked by the borrower, are really designed so that they are supposed to be simple enough that the borrower doesn't need an attorney. Okay. Now, if they do need an attorney, we're absolutely happy to help them. I help people all the time. Just what you do to invoke a loss mitigation option is you apply to your servicer, and the servicer is supposed to provide forms that allow that to happen. If the servicer, some servicers, as we all know, some companies do things the right way. Sometimes you get companies that do things that don't necessarily do things the right way all the time. And mortgage servicers are no different. There are some companies, I can tell you, if it's a mortgage servicer that I've dealt with before, they will do things the right way no matter what. Yeah. There are a couple of companies that I keep seeing again and again who don't do that. If a borrower needs help from us, we're certainly willing to help them fill out a loan loss mitigation option package to the extent they need our help, and we do that pro bono. Generally, if we get involved in the context of litigation, it's because we've run into one of those mortgage servicers who doesn't want to do the right thing. And in that case, we work on contingency.
Yeah, I think we're going to go to a commercial break, and then we'll be right back.
Yeah, well, let's step aside right here as we do so. A reminder of how you can follow Hollis Wright all over social media, Instagram, Facebook, Twitter. Just search Hollis Wright. You'll find them there. Really neat resource for you and some really helpful information on those sites updated all the time as well. So stay tuned. We've got more of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The The attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas. Bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, that's obviously the primary focus of the show.
We love helping people. I think everyone at this firm feels the exact same way, that the reason we do what we do is to help people. And this show gives us the biggest platform possible to help as many people as we can in the community.
Welcome back into the attorneys. Hey, attorneys from Hollis, Wright are standing by live all throughout the program. They're available right now. Give them a call, text, email. That free, confidential, and if it's a call, that all-fair conversation is yours for the taking here with Carter Clay from Hollis, Wright and Matt Carroll. Matt, let me ask you about kind of the most common scenarios and situations that you and your firm, what kind of cases are you all running into continually and consistently?
Right. That's a good question. The biggest area that we run into is a situation where the mortgage servicer made a mistake. And they made a mistake. Either they calculated the amount of the payment that was due. A lot of times they will add on extra charges that the homeowner thinks aren't owed. We see a fair number of cases where we are dealing with a borrower who got out of bankruptcy. And in the course of their bankruptcy, they did a 5-year bankruptcy plan. They made their payments under the bankruptcy plan, and they successfully completed their bankruptcy. But for whatever reason, the mortgage servicer miscalculated the amounts owed, and then after they completed their bankruptcy, the mortgage servicer came after them for a bunch of additional money that they said was owed, but it was inconsistent with what they claimed was owed during the bankruptcy process.
Yeah. Let's dive in right there in terms of RESPA. We've talked about that. That stands for the Real Estate Settlement Procedure Act.
Exactly.
And that's federal law that was passed by Congress, I guess, and signed by the president many, many years ago.
Right, 1974.
And I would also assume that individuals can go on the internet and could probably type that in, and there'd be a lot of websites that would come up that would help them educate themselves on what their rights and responsibilities are relative to that statute.
That's correct.
All right. In the context of the example that you just gave, and you may want to give some other examples as well, but if a person recognizes or believes there's an error in their mortgage statement, that they're not supposed to be paying something or that they're being charged for something they shouldn't be charged for, walk us through the steps and the process that they would need to take to make sure they do what they're supposed to be doing.
Absolutely. So under the RESPA statute that you mentioned, mortgage servicers have the option. So under the RESPA statute, if the homeowner believes the mortgage servicer has made a mistake, what they can do is they can send a written letter to the mortgage servicer saying, I believe you, here's my name, here's my loan number, here's my address, I believe you made a mistake, please conduct an investigation. And by law, the mortgage servicer has to conduct a reasonable investigation, and by law they have to conduct it within 30 days of receiving the notice of error, and then report their findings back to the homeowner. And by the way the statute is worded, they either have to respond with, we've looked at this, we've found we've made a mistake, we're going to correct it. Or they have to say, we've looked at this, we don't believe we've made a mistake, and here's why we don't believe we made a mistake, and here are the documents we relied on. And if they do that and they comply with those requirements, if they conducted it reasonably, that'll resolve the issue in most cases. Sometimes the mortgage servicer doesn't respond correctly. And if they don't, they can be held liable for any damages that they cause the homeowner and those damages can include out-of-pocket losses, mental anguish, their attorney's fees for having to fight this issue with the mortgage servicer.
You typically recommend that they send the letter by certified mail or by email. What's your typical recommendation in that regard?
My recommendation is this. I would send it by certified mail. And one mistake that I commonly see is homeowners get their monthly mortgage statement, they write their check, and they mail it to that address. When they find a mistake, if they are going to send a written letter, they tend to assume that the letter goes to the same address as where they mail their payment. Sometimes they'll even write, hey, I think there's an error on the payment slip. Under the RESPA statute, that doesn't count. It does not matter. It does not trigger any legal obligation on the mortgage servicer to conduct that federal statutory reasonable investigation that the statute requires of them. What most mortgage servicers do is they have a designated address to send their, that borrowers are supposed to send the notice of errors, alerting the mortgage servicer to the problem. In my experience, that address, that designated address, will almost always be written either on the front or the back of their monthly mortgage statement. And the language won't necessarily identify exactly what it is with great specificity, but it'll generally say something along the lines of, if you think you've made an error, send us written correspondence to this address.
Right. And are people typically coming to you and getting you involved at the point to where, I guess, the mortgage company has done their investigation, they've written them back, and they've concluded that there was no error or that the borrower is incorrect, and so that dispute still exists and they feel like they need additional help?
Honestly, I will tell you, most people that come to us before that stage. When they think there's an error, they've called their mortgage servicer, and the mortgage servicer has given them the runaround, or they've talked to some mortgage servicer representative who says, yeah, I see those charges on your statement, but it looks okay to us. Yeah. And they don't know what to do. Yeah. And so they come to us and they ask us, and we will typically help them write the initial letter.
Does RESPA only apply to homes and home ownership?
It applies, that's correct. It applies to residential housing. With one exception, it'll apply to rental housing of 1 to 4 units.
Okay, but otherwise it doesn't apply to commercial businesses and loans that you have take out for commercial
correct.
Buildings.
It won't apply to commercial, won't apply to agricultural or other business ventures. Yeah.
We only have a minute and a half left in this segment, but I'm curious, when it comes to these issues and mortgage-related issues like this, is it your experience, especially when folks kind of hit a tough patch and lose a job or some kind of financial calamity happens, to be more proactive than kind of hope things will turn around and, hope and pray and try to move it all around, try to do it on their own, kind of to be a little more proactive on matters of this and try to be upfront with what they're going through?
My experience, unfortunately, is just the opposite. My experience is that when people hit a rough patch, particularly when it involves the home and they're facing the possibility of foreclosure, too many people kind of are overwhelmed, understandably, but they're overwhelmed and they kind of stick their head in the sand and just hope everything will work itself out and go away. And my experience is that is the exact wrong approach, because there are these federal protections that are out there for them, but it only works if they invoke them before the foreclosure happens.
All right, let's step aside. Our final break of the evening. Let's take that break right now. As we do so, there's attorneys from Hollis Wright standing by for about 7-8 more minutes only. So you want to take advantage of that, go ahead and give them a call. Stay tuned. We're coming right back.
I'm attorney Bobby Bell with Hollis Wright Law Firm. In today's world, social media is all around us. It is common for many people to post on social media regarding their life and activities on a daily basis. Facebook, Instagram, Twitter, and similar social media are a great way to stay connected to others and to share your experiences and thoughts. Some seemingly innocent social media posts, however, can have devastating effects if you're involved in litigation, especially in a personal injury claim, a contested divorce, or a child custody battle. Courts regularly allow adverse parties access to the other side's social media accounts, allowing relevant posts to be presented as evidence. These rules have allowed social media to become a hotbed of information in the litigation world. In fact, we are seeing more and more preservation orders issued by courts requiring you to collect and save any and all social media activity. Therefore, it's advisable that even before there's litigation, lawyers should advise their clients that social media content may be discoverable. Here are a few helpful tips. 1. Do not post anything about the case. This includes posts regarding conversations or meetings with your attorneys, remarks about your injuries, negative remarks about the opposing party. Do not post anything you would not want read in open court to either a judge or jury. 2. Avoid new friend requests from people you do not know. Many law firms and insurance offices may attempt to have employees follow you on social media in an attempt to gain information. 3. Limit adding new photos, check-ins, photo tagging, etc. Seemingly innocent posts may be used against you. Regular check-ins at restaurants, parties, or other events with friends can cast doubt on any claims of loss of enjoyment of life, pain and suffering, or emotional distress, since you appear to be living life as usual. 4. Increase your privacy settings. Many social media sites frequently update and change their privacy settings. In the litigation context, it is possible you may have to preserve and present anything you posted. Therefore, we encourage you to be smart and careful when using social media. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys on WBTM 13.
Welcome back into The Attorneys, our final segment. Attorneys are standing by live. If you would like to take advantage of that opportunity, give them a call. Carter?
Yeah, Matt, let's talk a minute about somebody's having trouble paying their mortgage. They've run into financial problems, whatever the case may be, that has led them not to be able to pay their mortgage on time or a delay in payment. Number one, what should they do relative to the RESPA law? And number two, what are their options under the law as far as getting a loan modification or something along those lines to help them stay in the house without getting foreclosed on?
Right. So under the RESPA statute, there's and the implementing regulations that came in 2014 after the housing crisis. There's a regulation that requires a mortgage servicer to give a loan mitigation option package to the borrower, and how that happens is the borrower has to request it, and it's fairly simple to request it. There's no special magic to it. You just call the servicer and ask for your loan mitigation options. But it's better to send them a letter to show that you did ask for them. And then the servicer will send you a package, a pre-printed package for you to fill out, provide them information, what are the financial problems you're having, whether they're short-term, whether they're long-term, and information that the servicer then can use within their system to evaluate what options are available to you. My advice is if you are a borrower who has experienced or is in a difficult situation like that, apply for that loan mitigation option package as soon as possible. Don't wait until you're on the brink of foreclosure. For one, if you wait that long, your financial situation is going to be worse as you've missed more and more payments. But the other thing is, if you haven't asked for and completed your loan mitigation package at least 45 days before a foreclosure sale is scheduled to happen, then you've lost your right under RESPA to fully invoke those protections.
Now, what type of information, generally or specifically, would one expect to have to turn over to their mortgage company? Do they have to give like pay stubs, or do they have to give a letter from an employer saying I laid this person off? What would they typically have to provide?
That's a good start. Yes, what the servicer's looking for is, look, typically if the borrower can work things out, if they've had a short-term interruption because of a temporary health issue, they may have lost their job, but they expect to get another job within the next 2 or 3 months, it is better for the mortgage servicer's perspective to help the borrower work the problem out, because it costs less for the servicer to help a borrower who's just got a short-term problem keep their house versus incurring the cost of foreclosing. So what the servicer wants to see is that you're going to get past this problem. You're going to be able to, though you may miss 6 months of payments, after that 6-month period, you've got a good chance of having a new job or getting past your health issue and being able to resume your mortgage payments. And in those circumstances, they will, but so that's the information they're going to ask for. They want to be able to see that based upon their own criteria that you're going to have that, you're going to be able to successfully resume your mortgage payments.
Now, do they have to grant the loan modification request? And if they do, then what could a borrower reasonably expect a modification to look like?
Right. So there's no, the way the statute is written, there's no concrete requirement that they have to grant a particular loss mitigation option. It's really up to the servicer. But again, in my experience, if the problem that the borrower is experiencing is something that is, there's a good chance it's short-term, a 6-month job loss, that sort of thing, the servicer, at least the responsible ones, will work with you. And the most common mitigation options that I see in my experience is there's a short-term forbearance where they may agree that you don't have to pay your mortgage for 6 months, but they don't forgive the debt. They'll just tack that 6 months on to the end of the mortgage, but you're still able to keep your home. And then in the right circumstances, they will modify your mortgage so that you have a lower monthly payment. And again, it may involve also extending the term of your mortgage out, but you keep your house, you have a lower monthly mortgage payment that you can afford, and you get on with your life.
Yeah. All right, believe it or not, just 2 minutes remaining in the show, time enough to wrap things up from both of you. Matt, if you would, you go first, please.
Right. Well, let me say first, thank you for having me on. I've really enjoyed this, and I feel like this is an important issue to me, and I hope it's an important issue to a lot of borrowers out there who may run into trouble paying their mortgage. The biggest lesson I would say, and I mentioned it earlier, is if you run into a problem paying your mortgage, it is the worst thing you can do to stick your head in the sand and ignore the problem and think that things are just going to work out. But if you deal proactively and work with your servicer, I think you greatly increase your chances of keeping your home and avoiding greater financial problems and potential bankruptcy.
Yeah, and I would just mention we didn't get an opportunity to dive into the foreclosure process, but obviously if you don't make your payments and you get into the foreclosure situation and your house is foreclosed on, under the law you're entitled to try and redeem your house. There are complexities to that. It can be very difficult, but you do have a certain period of time where you can redeem the right to repurchase that house, get caught up in those types of things. Matt Carroll would be an excellent resource for somebody to contact if they have information about or have questions about that process.
Well, enjoy. Good job from the both of you. Interesting conversation. Thank you all for being with us. And I want to thank you all as well. Each and every week, you guys that join us, it means a great deal to us. So thank you for doing so. As we're wrapping up here, you see the ways you can contact Hollis, Wright. Feel free to do so. They will get back with you. So call, text, email, and get in touch with them there. Thanks so much for being with us. We'll see you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.